Well, good evening, everyone, and welcome to AJ 102. Tonight, we're going to be covering Chapter 2 in your textbook, The American Quest for Freedom and Justice, and talking a little bit about our laws. I am coming to you, well, not live, but tape delay, if you will, from poolside at my house. So hopefully you can see the picture of my pool, and if you can't, well, sorry about your luck. Um, if you look at your textbook in chapter 2, I think it's page 44, right towards the middle and towards the bottom, there are several definitions that are kind of bolded. And I think that it would be very good for everyone to look up these definitions, or at least when you go through chapter 2, make sure you pick these definitions out, because as we start to look at other chapters, some of these definitions are going to come into play. So knowing what some of these terms actually mean would be very, very helpful. By way of introduction, to ensure each U.S. citizen the right to life, liberty, and the pursuit of happiness. Those who settled here to establish these types of laws, or those that settled here establish laws that all of us are expected to obey. So the supreme law of the land is embodied in the U.S. Constitution and its Bill of Rights, and we'll talk about that a little bit later. Right now, I want you to take a minute and picture in your mind the scales of justice and the understanding and the complexity of being able to balance the needs of society with the needs of everybody's individual rights. So kind of keep that in mind as we start to talk about things, because it is a little bit more complex than you think. In fact, our system of laws is extremely complex and may be classified according to different things. And the first one would be form, which is written or unwritten common law; source, which is constitutional, statutory, or case law; parties involved, which would be public or private; and the offense, which would be criminal or civil. Now, when you look at types of laws, in addition to the classification of law provided in the introduction, several types of law must be understood to appreciate their complexities and effect on criminal justice. Recall that law is a body of rules for human conduct enforced by imposing penalties for their violation. The purpose, however, of law is to regulate individuals' actions to conform to the way of life the community or the people's elected representatives consider essential. So that in itself is extremely important. When you look at social or moral law, obedience to law is often obtained through social pressure, ridicule, contempt, scorn, or even ostracism. Moral or social law refers to laws made by society and enforced solely by social pressure. Moral or social laws include laws of etiquette, honor, and morality. When you look at common law and case law, we know that the beginnings of law are found in social custom. Custom is simply precedent, meaning doing what has been done before. In early times, custom, religion, morals, and the laws were kind of intermingled. Some early customs have, over the centuries, become law. Some customs were enforced physically rather than morally, and the violator was expelled from the community, sacrificed to the god, or hanged. Other violations of custom not felt to be harmful to the whole community were punished by the injured group or the injured individual with the aid of the family, or so on. When you start to look at a little bit, you look at this a little bit deeper, we're going to look at a couple of phrases called common law and statutory law. Let's kind of go to common law first. In England, common law referred to the precedent set by judges in the royal courts as disputes arose. So in England, the customary law set by judges as disputes arose, the law enforced before independent of legislation. This is known as common law. The common law brought to the United States by the early settlers forms the basis of modern American law in all states except Louisiana, which established and kept the system of the French civil law. In essence, common law describes the precedent generally followed in the absence of a specific law, known in the United States as case law. Case law refers to judicial precedent. No specific law exists, but similar cases serve as a model. So if there's a court case that's already been decided and judges are looking at a new case, they're going to look at that case law, that precedent that was set before, to help them make a decision. Now, in the United States, we also have this thing called statutory law, which is law passed by legislature, and those are in the Penal Code. Big, fat, blue book that has every single code that you can imagine in it. The United States has largely replaced common law or unwritten law with this thing that I just described to you called statutory law. That is, legislated and written law. Statutory law may be passed at the federal, state, or local level and includes constitutional, criminal, and civil law. And we'll talk a little bit about civil law in a few minutes. And then finally leads us into this thing called equity. Equity demands that laws change as society changes, resorting to general principles of fairness and justice whenever existing law is inadequate. It requires the spirit of the law to take precedent over the letter of the law. So again, equity, a concept requiring that the spirit of the law take precedent over the letter of the law. Prime example of equity is a traffic stop. You get pulled over and the officer has the discretion to write you a ticket going by the letter of the law, what's written in the book. You violated the code, you're going to get the ticket, you're going to pay the fine. Or the spirit of the law, where maybe the flow of traffic was high, people were moving very quickly, and the officer is going to use some discretion and not issue you the citation. So those are in fact the two differences. So now we'll move to the Declaration of Independence and talk about this term called the American Creed. The American Creed, by definition, is the belief in individual freedom. As noted by the author's name is Myrdal, M-Y-R-D-A-L, and this is 1944. And he says the American Creed is the national conscience, a body of beliefs about equity, liberty, and justice, which most Americans believe in spite of the fact that America has and always has had multiple wrongs. In the 1760s, British began taking away the rights of Americans, and they felt that were naturally theirs. And as a result, the American Revolution kind of came about. In effect, the United States was born out of a desire, indeed a demand, for civil rights and civil liberties. Now let's make sure that we understand the difference between civil rights and civil liberties, because there is a difference, and I want to make sure that you're well aware of that. So civil rights are those claims that citizens have to the affirmative assistance of government, okay, as opposed to civil liberties. Those are an individual's immunity from governmental oppression, okay? And then to define the Declaration of Independence, so you kind of know exactly what that is, but I think you do. The Declaration of Independence asserts that all individuals are created equal and are entitled to the unalienable rights of life, liberty, and the pursuit of happiness. It also further asserts that governments are instituted by and derive their power from the governed. That is the people. That would be you. So, you know, another thing I need you to kind of pay attention to, because we're going to go through this pretty quick, is I need you to make sure you read the chapter, so when we go through this, you can make sure that you pick up all the parts that I'm not able to actually hit. So let's look now about the Constitution, the U.S. Constitution and the system. The Constitution is a system of fundamental laws and principles that prescribe the nature, function, and limits of a government or other body. The U.S. Constitution was drafted by the Constitutional Convention of 1787 and became effective in 1789. Now, the U.S. Constitution ratified in 1789 is the basic instrument of government and the supreme law of the land. The U.S. Constitution laid the foundation for the criminal justice system by establishing what, you ask? Well, let me tell you, there's three parts to it. First, they established the legislative branch that makes the laws, the executive branch that enforces the laws, that would be the police, or the sheriff, or highway patrol, or what have you, and third, the judicial branch to judge when the law has been broken. All three branches of government served as a system of checks and balances on each other, providing what they call a lateral balance of power. And last is this little piece called federalism. And this is a principle whereby power is shared by the national government in the United States. Federalism allowed the criminal justice system to develop at both the state and federal levels and establish a vertical balance of power. So now we're going to take a quick peek at the Bill of Rights, and I would suggest that you go through and you Google the Bill of Rights so you know, in fact, even though we're going to cover some of these, what the first 10 amendments to the U.S. Constitution are. I mean, those are the Bill of Rights, but you're going to need to know a couple more, so let's talk about that. So the Bill of Rights is the first 10 amendments to the U.S. Constitution, and there are some that are a little bit more important for law enforcement than others. So we're going to take a look at individual constitutional rights that are clearly specified in each amendment, again, of special importance or significance to criminal justice professionals would be the first, second, fourth, fifth, sixth, eighth, ninth, 10th, and the 14th Amendment. So just very, very quickly, and you can go in your book, in your textbook, and read a little bit more about these. The First Amendment guarantees freedom of religion, freedom of speech, freedom of the press, freedom of peaceable assembly, and the freedom of petition. The Second Amendment guarantees the right to keep and bear arms as necessary for a well-regulated militia. And some people get confused on that. Well, that means I have the right to carry a gun and bear arms. Well, yes and no. You have the right to defend your castle, which is your home. You do have the right to defend yourself, but there are laws that prohibit you from carrying a loaded firearm in the waistband of your pants. So understand that although the Second Amendment guarantees the right to keep and bear arms, it doesn't give you the right to walk down the street with a loaded AR-15 or something like that. So just these are things that you have to kind of understand, which is why it's really important that you read those amendments and some of the laws that we covered. The Fourth Amendment requires probable cause and forbids unreasonable search and seizure. This is one of the bigger ones when it comes to law enforcement, because many cases are won and lost on the officer's ability to search and seize properly. The Fifth Amendment guarantees due process, notice of a hearing, full information regarding the charges against the person, the opportunity to present evidence in one's defense or behalf before an impartial judge or jury, and the right to be presumed innocent until proven guilty. The Fifth Amendment prohibits double jeopardy. I'll talk about what that means in a minute. Wouldn't it be different? I mean, right now, remember, you're innocent until proven guilty. What if you flop that around and you were guilty until proven innocent? You could see how that would be very, very difficult. So that's the protection that you get in that Fifth Amendment. Going back now to double jeopardy. The Fifth Amendment also guarantees that citizens will not be placed in double jeopardy. That is, they will not be tried before a federal or state court more than once for the same crime. A second trial can occur, however, when the first trial results in what they call a mistrial, meaning when the jury cannot agree on a verdict when the second trial is ordered by an appellate court. So if you get tried once and they find you not guilty, they can't simply do a retrial. If you get tried for a particular crime and it's a hung jury, they can't decide, then of course they can retry you, and that would not be a violation of double jeopardy. Self-incrimination is based on one of the larger landmark case decisions, Miranda versus Arizona 1966, that basically says citizens must be warned before custodial interrogation of the right to remain silent, that what they say may be used against them in a court of law, and that they have the right to counsel, and if they can't afford that right, one will be appointed to them. This is a huge decision, and I really suggest that you read a little bit more on Miranda versus Arizona. The Sixth Amendment establishes requirements for criminal trials. It guarantees the individual right to have a speedy public trial by an impartial jury, to be informed of the nature and cause of the accusation, to be confronted with witnesses against you, for you to be able to use the subpoena power of the court for witnesses in your defense, and to have counsel for your defense. So again, for many years, this right to counsel was kind of interpreted to mean that the defendant had a right to be represented by a lawyer if they could afford one. Well, there are a couple of big cases in there. One is Gideon versus Wainwright, 1963, which changed that, basically saying that, if you cannot afford to hire a lawyer, one will be appointed to you because you have the right to due process and representation. So moving on real quick, the Eighth Amendment. The Eighth Amendment forbids excessive bail, excessive fines, and cruel and unusual punishment. Most people know what bail is. And cruel and unusual punishment is more like this. Whether fines and confinement are cruel and unusual must be determined by the facts of each case. So they're not talking about merely use of force stuff. They're talking about cruel and unusual punishment when it comes to bail, fines, and things like that. So again, I would suggest that you read the entire amendment. The Ninth Amendment emphasizes the Founding Fathers' view that government powers are limited by the rights of the people, and that it was not intended by expressly guaranteeing in the Constitution certain rights of the people to recognize that government has unlimited power to invade other people's rights. The 10th Amendment embodies the principles of federalism, which reserves for the states the residue of powers not granted to the federal government or withheld from the states. And the 14th Amendment, the last one that we're going to kind of talk about tonight, the 14th Amendment requires each state to abide by the Constitution and the incorporation doctrine of the Bill of Rights, and it guarantees due process and equal protection under the law. So again, when you start looking at these first 10 amendments, because they are very, very important as it relates to you getting a good understanding of criminal law and how this really applies to doing your job here. So criminal law and some of the features, defining crime and fixing punishment, and this phrase that they call substantive criminal law. So criminal law basically is the body of law that defines crimes and assigns punishment. So basically, every crime has a punishment, so that's the criminal law. Substantive criminal law basically says that those are statutes specifying crimes and their punishment. So let me kind of read into that a little bit more and see if you can get a better idea. The Bureau of Justice Statistics defines crime as all behaviors and acts which a society provides formally sanctioned punishment. Crimes are made so by law. State and federal statutes define each crime, the elements involved, and the penalty attached to each. The statutes that define what acts constitute social harm are called substantive criminal law. For example, a statute defining homicide. A substantive criminal law not only defines the offense, but also states the punishment. Hopefully that kind of makes a little bit of sense to you. For us, we understand crime in a very more simplistic view. We look at like classifications of crime. So there's two that we kind of know. There's actually three. But so there's first is felony, which is the highest one. It's a major crime. For example, murder, rape, arson, the penalty of which is either imprisonment for more than 1 year in the state prison, some large fine, and possibly even death. The lower one below that would be a misdemeanor. It's a minor offense, for example, like breaking a municipal code ordinance or vandalism or something like that. Typically punished by a fine and less than 1 year in what they would call a local or a county jail, and maybe something different. And then an infraction, of course, it would be like a traffic ticket. So those are kind of how you look at the different levels of crimes that we have. So remember, felony is the most heinous, if you will. Misdemeanor would be second, and then finally third would be an infraction. In addition to establishing what specifically constitutes a crime and said punishment for it, procedural criminal law specifies what must be proved and how that is legally within the constraints of the Constitution and the Bill of Rights. So to prove that a crime has been committed, it is usually necessary to prove a couple of different things under procedural criminal law. And these two things are phrases called actus reus and mens rea. Actus rea basically means the act itself, the material elements of the crime. Mens rea basically means the criminal mental state, the intent to do wrong. So material elements, the criminal act. Basic to the commission of a crime is that concept of actus reus, literally the guilty act. The actus reus must be measurable act, including planning and conspiring. Then the second part that we already talked about, but I'm giving you a little bit more here, the criminal intent or the mens rea. The second key element requirement of a crime is the criminal intent or the mens rea, literally meaning guilty mind. So those are a couple things that really need to be focused on when you're talking about proving your case. The general rule under U.S. law is that, and we're going to kind of move on and keep talking a little bit more about civil law and torts and some distinctions. We're going to talk about liability and a couple other things here. The general rule under U.S. law is that ignorance of the law or mistake of the law is not a defense in a criminal prosecution. In some crimes, intent is not an element either. These are known as strict liability crimes. So again, strict liability, intent is not required. The defendant is liable regardless of his or her state of mind when the act was committed. Strict liability crimes generally involve things like traffic violations, liquor violations, hunting violations, things like that. Here's an example. A liquor store owner cannot use the excuse that a minor who bought beer from the store looked 30 years old. Okay, does that kind of make sense? Nor can a speeder claim ignorance of the posted speed limit or claim faulty speedometer. Intent is not really the issue. The issue is like the speed or the fact that you sold somebody, the beer or what have you. Quickly, intent versus motive, and it's not up here, but I kind of want to get that out. Intent is not to be confused with motive, which is the reason for doing something. Motive is not an element of any crime, but of course it can help you do that. So the motive is the reason for doing something, why you're doing it. Your intent is different. So a motive might be that you're a burglar, and when you break in, you open up somebody's drawer and you take only one certain item out. And every time you do a burglary, that's what you do. That that could be your motive, whether it's sexual arousal or the thrill or whatever it is. So that's the motive. Okay, so again, the reason for doing something. So we covered strict liability. We covered a couple other things there. Let me make sure. Okay, so let's move on a little bit here and look at civil law and torts and kind of a difference between the two. Civil law refers to all non-criminal restrictions placed on individuals. It seeks not punishment, but resolution. The offense is really called a tort. So again, civil law, all restrictions placed upon individuals that are non-criminal in nature, seeks restitution rather than punishment. A tort is a civil wrong for which the court seeks the remedy in the form of damages. So here's kind of how I'm going to kind of show you the difference between these two. So a crime is a public wrong. The state prosecutes the person. We seek to punish by like time or whatever. And criminal intent one way or another is kind of required, well, for most. For a tort, it's a private wrong. The individual prosecutes by taking somebody to court. We seek redress for injury, compensation. So the intent really doesn't matter. Hopefully that kind of makes sense to you. A little bit further on civil liability. The threat of civil liability can affect police officer response, including arrest decisions, by creating what we call lawsuit paranoia that can permeate and undermine the effective operation of law enforcement agencies and can affect every law enforcement officer, both professionally and personally. In one case, an officer reported that his partner did not fire on an offender, pointing two pistols at them because they were afraid of liability and the fact the pistols may not have been real. The offender shot and killed one of the officers. These officers were more afraid of lawsuits than being killed. So when we talk about policing, and we're going to get into this later on, law enforcement, you are subject to lawsuits in certain situations. And again, we'll get more on that. Civil Rights Act, Section 1983. Section 1983 of the U.S. Code, Title 42, stipulates that anyone acting under the authority of local or state law who violates another person's constitutional rights, even though he or she is upholding the law, can be sued. Okay, so we're talking here more as in the law enforcement realm. Okay, so that really kind of brings home the fact of, can you be sued? Well, you can't. Finally here, levels of intent. We see first strict liability. The wrongdoer is liable even if no harm was intended. For example, keeping wild animals or something like that. Next, intentional wrong. The person knows the act was unlawful but did it anyway. And then finally, negligence. The person did not set out to do harm but acted carelessly, which in fact is a form of negligence. So now we're going to move on to police power. And again, I want to make sure that I get this done in like 30 minutes or so bear with me, and then make sure you fill in the gaps by reading your textbook. Police power is derived from a lot of different things. Police power describes the ability of federal, state, or municipal governments to enforce the laws they pass by granting government agents at each level the authority to use force against those who fail to comply with laws. Police power is derived from the U.S. Constitution, U.S. Supreme Court decisions, federal statutes, state constitutions, state statutes, state court decisions, and various municipal charters and ordinances. And if you look on page 65 in your textbook, it's going to kind of show you a diagram of, where that police power comes from, the sources of police authority. It's listed in figure 2.2. And you can take a look at that diagram there's a diagram right there. Didn't know I had it. Smarter than I thought. So here it is. This is the authority wheel, if you will, that kind of shows police power. You get it from the citizens, you get it from government laws, federal, state, and local, the Constitution, the Bill of Rights, federal, from the courts, the federal, state, and local, and this is how we basically obtain our authority. The needs of society and the rights of the individual. America was founded on the desire for liberty and freedom from England's tyranny. I know that was a long time ago. Although the founding fathers crafted our government to ensure it would not impinge on the individual liberties, the desire for law and order was also strong. They had brought with them the common law of England, and it was expected that these laws would be obeyed. But, again, there are some things that didn't really go well. The scales of justice symbolize the desire, which I said earlier, to balance the needs of society with individuals' rights. Now, there's a couple of different theories and views of what we call this social control. So really quick, conflict theory contends that certain behaviors are criminalized to keep the dominant class in power. Now, I'm not going to kind of give you my take on some of this, or maybe I will later on, but I'm just going to kind of throw out the points of the theory, and I will let you kind of come up with your own thoughts on this. Consensus theory holds that individuals within a society agree on basic values, on what is inherently right and wrong. Acts that are wrong are considered crimes. This theory goes back in history, at least as far as Plato and Aristotle, and I'll kind of stop there. Crime control versus due process. That due process phrase is in fact a constitutional guarantee. A major function in our criminal justice system is crime control. However, the Fifth Amendment of the Bill of Rights and the Fourth Amendment both guarantee citizens due process of law. So we need to make sure that, we're enforcing the laws, but we're doing it within the guidelines that are given to us to work with. And then last here, conservative versus liberal crime control policies, real kind of quick. Conservative crime control policies are draped explicitly in the metaphors of war. We have declared war on crime. We've declared war on drugs, which are presumed to promote crime. In contrast, the liberal crime control approach emphasizes correctional policies, broader social reform intended to expand opportunities for those locked out of what they call the American dream. Now, again, you're going to have your own opinion on stuff like this, maybe a combination of both. Yes, we do need to declare war on drugs and war on crime and things, but at the same time, we need to have reform and things in place for people to where, if they do violate the laws, they do go to prison, let's say that when they get out, they have the ability and opportunities that everybody else has. And I know that, probably a lot of you might agree with that. Law and policy versus discretion. Discretion is extremely important when it comes to policing, and again, we may even spend a part of a chapter on this, but I want to make sure I get through this in a timely fashion. So discretion is the freedom to make judgments that affect not only individuals, but also the entire criminal justice system. Discretion is exercised by legislators, police, prosecutors, judges, correctional officers, and paroling authorities. Some feel that there should be one set of rules for law enforcement, courts, and corrections that would permit little, if any, discretion at all. Others point out, because no case is identical to the other, allowances must be made for wide degrees of discretion for law enforcement, courts, and corrections. So I'll let you kind of figure out which one of those you think you might fall into. But I think, in this job of policing, discretion is truly important. So again, it may be found throughout the criminal justice system, one set of rules, swift and certain, and we talked about allowances and no case being identical to the other. There's a couple of phrases out there called retributive versus restorative justice. I'm going to define those for you. So, retributive justice is a system where a person who breaks the rules must pay, kind of like an eye for an eye. And the restorative justice philosophy is a framework that focuses on crime as an act against another individual rather than against the state, focuses on the harm done and how that harm might be repaired, if you will. The goal is to reconcile the needs of the victims and offenders with the community's needs. So we'll talk more about restorative justice later on, but there are some definite benefits and some definite issues to go along with it. And then finally, we're going to look at this last piece right here called the criminal justice pendulum, and it's in your book. It's on page 70, I think, and it's kind of a duality. So to the right end is crime control and rigid adherence to the law and retribution, and to the left end is like due process and discretion and restorative justice. And that pendulum moves depending upon what decade we're in and how things are going in law enforcement. The trick again is to try to find some type of balance, but there is that pendulum, sways from side to side and kind of ebbs and flows, if you will, depending upon really what's going on. An interesting thing also in your book in table 2.2, right above that pendulum on page 70, on the left-hand side column, it talks about some things attributed to retributive justice, and on the right-hand side, it talks about those things attributed to restorative justice, and you can get a kind of look at those and see which one you might think are, you might adhere more to. That criminal justice pendulum, just to finish up, the dual responsibility of seeking out and punishing the guilty while simultaneously protecting the innocent is one of law enforcement's greatest challenges, and I'm going to kind of leave it at that. So that's the end of chapter 2. And if you have any questions, you can post them on the general question bulletin board. And again, don't forget to read your textbook to make sure that you fill in all of those things that maybe I didn't get a chance to get to. And hopefully the photo of my pool was able to show up so you could, kind of relax and cool off while we're doing the lecture. So until next week, that is the end of chapter 2.